Feel free to change your Zoom name or turn your camera off if you don't want to be part of that video, but we're gonna start recording. My name is Sophia Optikar. I'm a faculty member at the School of Labor and Urban Studies and a member of the PSC. And when we worked on this event, we were motivated by the fact that our union delegate assembly recently passed a strike readiness resolution. And this probably experience for a lot of us whenever we talk about strikes or getting ready for a strike as public sector workers in New York, we of course have concerns about the Taylor Law, the infamous Taylor Law that imposes penalties on us if we strike. So members often have questions about what the Taylor Law is. And in this event, we hope to hear about the history of the law, get a little bit about the little bit more information about the details of what the penalties are, how it all works, but also to be inspired to fight this unjust law and to imagine a future beyond the Taylor Law. We are very happy to have three excellent panelists with us today. First up, we will have Arthur Schwartz, who was a general counsel for TWU Local 100 during the 2005 transit strike, and was also general counsel for the PSC in the early 2000s. And he's currently running for the New York City Council in District 3. Then we'll have Cena Moore, who is the chair of the PSC's Hunter College Campus School Chapter, who's going to tell us about actually building towards strike readiness and voting to authorize a strike in that chapter, which is what happened recently there when over safety precautions. And finally, we have Mark Keagan, who is a graduate student and adjunct at Lehman College, and whose dissertation is on the TWU Local 100 and spans two transit strikes of 1980 and 2005. The panelists will speak for about 10-15 minutes each. If you, as questions pop up for you, please put them in the chat. We'll be monitoring the chat. And after the panelists are done, we will open it up to questions and answers. And we really hope for a robust engagement from all of our participants. And special shout out to all the PSC members who are here in this room, but also our friends from SUNY unions and DC 37 and others who maybe I haven't noticed in the chat. So first up, we have Arthur Schwartz. Take it away.
Good evening. Everybody hear me? Yes? Yes? No? Do you hear me?
Yes, you're fine,
Yes.
Arthur.
Oh, okay. I've had experience of not being heard, even though my mic was off. So, I want to start off by just talking a little bit about the word, the Taylor Law, the words, the Taylor Law, because the Taylor Law really is a law that's properly known as the Public Employee Fair Employment Act, which has a lot more in it than the prohibition of striking. It is a law which was passed around 1972, which had the purpose in part of prohibiting strikes and creating a mechanism for addressing strikes by public employees, but which in return, the state legislature gave public employees much broader rights than they had ever had before. The Taylor Law is, in a lot of ways, is like the National Labor Relations Act for public sector employees in some ways. It gives unions the right to organize. It gives unions the right it creates a mechanism by which unions can petition, get signature cards, and petition and get recognized to represent groups of employees. And believe it or not, Not all public sector employees are unionized. I've been involved in several drives over the last 3 or 4 years at the MTA with groups of employees that were not unionized, where we had to collect cards and have a fight over who was supervisors and who wasn't supervisors. So it creates a mechanism for doing that. It also creates a mechanism to compel employers to bargain. There's a requirement that employers bargain, although I'm going to let Mark talk about this later. There are prohibited subjects of bargaining and mandatory subjects of bargaining. And then it also creates a system of unfair labor practices, which they call improper practices, where employees who engage in union activity um, uh, can can bring a charge against an employer for retaliating against them for engaging in activity or prohibiting it in some way, shape, or form. And it also creates a mechanism for employees to bring charges against unions that aren't properly handling their grievances in the course of arbitration. In fact, pretty much these days it's the only way for an employee to whose union is not representing him. There used to be a way to sue in court, and the courts have basically eliminated that. So it's a whole series of rights that go way beyond strikes. And before the Taylor law, there was it was basically it was the wild west, right? Unions could organize, they could try to force the city or the state or a municipality to deal with them. In some cases, they were successful. There were some unions that went back to the 1940s that grew out of the union movement of the CIO, like what's now called Local 371, which is also the Social Service Employees Union, which represents social workers. And the Transport Workers Union was one of those unions, although the TWU was originally organized when the Transit Authority uh, they began when the Transit Authority was not a transit authority. Uh, as I heard Mark say earlier today, those of us who were over, I don't know, 50, might remember there was such a thing as the BMT and the IND and the IRT lines. Those were actually private companies that became public. And most of the bus lines that run in New York City were private companies that became public, and they got folded into a public authority because they couldn't make money. Um, because there wasn't any organized system, there wasn't a very organized legal mechanism to deal with public employee strikes. Now, public employee strikes are dealt with. It's a state by state matter, um, and some public employees, particularly in the railroads, can strike if they go through a particular um, a procedure. But in New York, there was a prohibition in the 1960s that was called the Condon-Wadlin Act that prohibited striking, but it just prohibited striking. And so the employer, say in 1966, the New York City, the Transport Workers Union went on strike. Uh, the mayor, according to my quote, a guy named John Lindsley, um, went to court because the Transit Authority at the time was a city agency, and they went to court under Condon Wadlin, and they got an injunction, and the union didn't listen to it, and the union got fined for contempt, and Quill got put in jail. Um, and it didn't. There were a number of strikes in New York City in the 1960s. The the bridge workers went out on strike one year. They left all the bridges open all over the city. There are bridges that go over the East River and the Harlem River that open up or turn, and they just turned them and then left, right, and walked off the job. In 1968, the New York City, the U of T, the teachers union went on strike against community control of schools, and they were on strike for about, my recollection is 12 or 13 weeks. And they also faced an injunction, which they didn't listen to, and they did eventually get fined for doing what they did. Or it may even be that in those days, as part of the condition of returning to work, the city waived the penalty, waived the contempt citation. I think actually that's what happened then. So there were a lot of public employee strikes that were going on in the 1960s. So the state legislature decided to codify, to make a better procedure for dealing with public employee strikes. So they, so as part of the trade-off, they said, we'll give you all these rights. We'll give you union rights, which is different than the rights that private sector employees have, the right to concerted activity around wages, hours, and working conditions. That's protected. Public employees have, and I'm talking now, not New York City employees are covered by yet a third law called that just covers New York City employees, but it's very similar. But you guys are under the Taylor law. You're under the state law, and that protects union activity. So if you stand up and say, we need more wages, we need higher wages, and you're not doing it as part of a union effort, in fact, it's not protected, and you can actually be retaliated against under the law. You may be protected under the First Amendment, because as a public employee, you have First Amendment rights vis-a-vis your employer. And those First Amendment rights include a right to agitate for the well-being of your fellow workers. It could also involve protesting racism and discrimination. It could involve protesting unsafe working conditions. So that there's a First Amendment element to what public employees have, but it's not, unless it's done as part of a union, it's not protected under the Taylor law. The trade-off that, as far as I think the legislature was concerned, that they gave to the unions was they passed Section 210 of the Taylor law, which says no public employee or employee organization shall engage in a strike, and no public employee or employee organization shall cause, instigate, encourage, or condone a strike. So those words are pretty broad: cause, instigate, encourage, or condone a strike. In 1999, the Transport Workers Union was, I think, a dissident caucus that Mark was actually a part of at the time, called a union strike meeting, and where they were able to take over the stage at a big union meeting. And there was the mayor at the time, a wonderful person named Giuliani, went to court and got an injunction that said if anybody said the word strike, they could get fined. It not only prohibited a strike, and it wasn't brought under the Taylor law, it was brought under, some old common law notion of that it was created a nuisance for the people of New York. But it was this draconian injunction that said if anyone mentions the word strike, they get fined $250. And the union's executive board, ran out of the meeting and said they voted not to strike. But had no one got prosecuted under that injunction. But had that happened, there would have been serious First Amendment problems. In 2002, the union again was saber rattling about a strike and actually took a strike vote. And the mayor then, some guy named Bloomberg, who made like he was going to ride his bike to work every day, and who also was not the person in charge of dealing with the Transport Workers Union, went to court and tried to get a similar injunction and was not successful, because both the TW and the UFT at the time, we went into court together to challenge that on First Amendment, what he was trying to do on First Amendment grounds. 2005 was different, and we saw the whole panoply of what could go on play out. But and I'll get into that in a second. But when the union thought it was going to head towards a strike, they called a strike meeting, and we actually went to court to ask the court to issue an order declaring that we had the right to have a strike meeting before the authority went into court to have it declared a violation of the Taylor law, because by voting to strike, we were instigating, encouraging, or condoning a strike. And we thought that, some somebody might read the statute that broadly, so to say that we couldn't do that. And we went in and said that we argued that we had a First Amendment right to have the strike meeting, and the judge agreed with us. The judge said that the statute was only designed to stop the imminent encouragement of a strike. But this was several weeks before the contract was expired, and he said that since it wasn't going to create an imminent strike, that it was protected under the First Amendment, and the union had 10,000 people show up and vote to authorize the executive board to strike. Now the the remedies have some value, and I'm going to get into that the value a little later. But when a public employee union is going to strike or is striking, the under Section 210, the Attorney General of the state of New York has to go to court to seek an injunction. That's what it says. It's not the mayor of New York City. It's not the authority itself. It's the Attorney General has to go into court to seek an injunction on behalf of the entity. And it was interesting because in 2005, the Attorney General was a guy named Spitzer, and who later became governor, and he was very pro-union and wasn't actually that thrilled about having to go into court against the TWU. And the authority actually went and hired Proskauer, which is a big firm, to be co-counsel with him, and they were far more virulent. And then, of course, there was the city's attorney, who was the most ludicrous person of all, um, and um, and so they went into court, and the judge wouldn't order anything until the union actually took the vote. So they went into court, and the judge issued an injunction. And I remember the union voted at around 3 a.m. to strike that day immediately, because the contract was up at midnight. And at 3:05, the judge was on the phone telling me to be in court at 5 for that he had issued a temporary restraining order, and to be in court at 5 to deal with a motion for contempt unless the union called off its strike immediately. Um, the the way that the Taylor law gets enforced at that point is the court um, is required to issue an injunction to stop the strike, and then if the strike continues, then they proceed with a contempt hearing, which allows the court to enter fines against the union for striking. And at the time, there was a lot of we actually weren't dealing with the amount of the fine, but simply about whether or not the union was putting up. We had various defenses. We said that the employer was trying to get something out of negotiations, which it wasn't allowed to get, and and that the strike was permitted. And we put a lot of testimony on, and we dragged out the proceeding for 3 days until finally the union had made a deal to go back to the bargaining table and tell everybody to go back to work. What follows after that?
Arthur, can you start to wrap up, please?
Okay. What follows after that is that the union then gets its fine. But the other thing that happens is the union must lose its right to have dues checkoff for some period of time to be determined by the court. And so in that particular case, the judge, suspended dues checkoff, which made it very hard for the union to survive because it had to collect hand by hand dues from people. And and in that case, it lasted 17 months. Even though the Transit Authority agreed to have it end after 2 months, the judge decided that he wouldn't lift the suspension until the union pledged not to strike again, and the union didn't want to do that. And so this standoff went on for 17 months. The union they got fined $2.5 million, and they lost about $17 million in dues. And as I said earlier today, transit strikes happen about once per generation, because people have to, and the other penalty that happens is every worker who goes on strike they lose that day, and they lose a day's pay for the day that they were on strike, and that just gets assessed against them later. So the penalties are pretty broad. The one last point I want to make is that, and this might come up later, is that for smaller job actions, where somebody maybe walks off the job for an hour and then comes back. The mechanism of getting a Taylor law action together is harder for the employer to do because it's a big rigmarole, and they can't bar something that's already happened or penalize something for or as easily for something that's already happened. And then, so you do see unions engaging in short job actions. The last point is encouraging, condoning, taking strike votes is lawful and has not ever really been enjoined under the Taylor law.
Thanks, Arthur. Super interesting. I'm sure we'll have lots of questions for you in a bit. Next up, we have Cena Moore from the Hunter College campus schools to share her recent experience with actually organizing her chapter to vote on the strike resolution. So,
Hi, everybody. I have a yellow box around me, so I'm assuming you can hear me. I want to once again thank Mark for sort of reaching out to me. His brother is actually on our executive board at the campus schools, and I actually met Mark only once, and I met him through one of these, the only protest that we had sort of surrounding our struggle in the summertime. So I'm going to talk to you guys a little bit about our struggle, but I want to also give you a little bit of background information about our school. So we are a K through 12 school, and we are not a part of the DOE. We are part of CUNY, obviously, and we are sort of this isolated little entity, I guess, because we're different than all the other campuses because we are a high school. So we have a K through 6 element, which is the elementary school, and we have a 7 through 12 element, which is the high school. Each school has their own principal, assistant principals, so that's different than the colleges where you guys have chair people. And then we have a director of the campus schools, and she's who we mostly deal with, like the union mostly deals with. Both the schools, elementary school and high school, kind of function separately, but I do represent, the chapter represents both of them. And each community is very tight. There's only about 25, 30 elementary school faculty and about 90 high school faculty. So over the year prior to the pandemic, there was a lot of construction going on, and our building is this armory, this no windows really. And then we had all this construction going on, and there was a lot of dust and signs up and stuff like that. So concerns arose over the health and safety of our building during this time of construction. So we planned and we met, we got introduced to Jean Grassman, who's from the PSC Watchdogs, and she agreed to come and do a walkthrough of our building. That would have been the first time we would have met her. Well, it is the first time we met her. The day before the walkthrough, I gave a courtesy call to my director, letting her know that she was coming. And once I did that, I got sort of frantic text messages from my director, and she actually came to my room the next day, my classroom, while I was teaching, telling me to stop her from coming. She's not going to be allowed in, da 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 da. Well, she was already on her way, and I wasn't going to stop her. But we did get met with security at the front door, telling us that she couldn't come in, and then they pulled our director, her name is Lisa Sigmund. They pulled her out for us to argue. We argued back and forth with her, trying to get Jean in. And I would say we put up a good fight, but the higher ups had spoken, and Lisa was sort of like their soldier, and she wasn't gonna reason with us at all. That was it. So I guess I should backtrack a little bit. I got the chair job originally because the actual chair retired. And I was listed as the vice chair, and I didn't know that meant that if he retires, I become the chair, which is what happened. And then I sort of ended up, running for the position, and I got it. But as soon as I got into that position, we were like a really small board before that, and we expanded a little bit. I could tell there was more interest. I had some, and I started gathering emails because we didn't even have a way to communicate with our faculty besides using the regular email. So I started gathering emails so we could communicate. And so once this denial of the walkthrough happened, I was able to just immediately communicate to the community what had happened. And the mistrust of our administration grew at that point. You know, it's like, what are they hiding? Why can't we do it? And so a lot of concerns arose over that. And then the pandemic, well, it was more the week of March 6th, I remember, and there was a lot of like concerns. People were, you know, COVID was starting, and so the school really, a lot of the teachers were like, we need to close, we need to close, we need to close. And so over the weekend of March 13th, I had the fortunate pleasure of having a wonderful phone call with Jennifer Robb, where, you know, she tried to act like we were friends and say, what should we do? Da, 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 da. When basically, I think the DOE was closing on Monday, so they decided that we should also close on Monday. And so, you know, all the schools closed, including ours at that particular point. So I guess fast forward to I guess we had a lot of, she kind of is, she's the president of Hunter College. So we had some meetings with our administration during the spring, and us as a union tried to really put forward this line of, we need to collaborate, we need to really figure these things out together, we need to communicate with each other, we want to help as much as we can, yada, yada, yada. And so we left the school year feeling like that's what was going to happen. And then around mid-July, we emailed to be like, okay, when can we start talking about the reopening plan? And I guess they set up a meeting with us for the beginning of August. And at that point, they had already made the reopening plan with no input from us. So that was once again a little, you know, stab at us or whatever. And, you know, so then the meetings just begun. Meetings after meetings after meetings, Zoom meetings. We had Zoom meetings with our teachers. We had meetings with the administration. We had executive board meetings. You know, a lot of the people from PSC started to get involved with us, helping us, guiding us. We ended up having people from our community really step forward with different skill sets. So we had a science teacher who was just very knowledgeable. You know, every time we had a big meeting, she would speak about all of the COVID, all the knowledge around COVID and building safety. She knew a lot of that stuff. And so she became really involved, and she was very adamant. And she's now actually a part of our board. And then we had another person step up and who just really wanted to help us, because we have a huge parent community. You know, we have all school age children, and the parents are the one that really advocate for their kids. And so he set up a email blast to all the parents, because they weren't getting any information from us. Everything they were getting was from the administration. And so we really got a lot of support in that way. And so then we did a couple of no confidence votes. And but before we did any no confidence votes, before we did any strike authorization votes, we did tons of like phone calls too. We had to make phone calls to every single person, basically, whether we wanted to talk to them or not. We had to talk to them to find out where they were so that we could get assessments. And all of this was sort of guided by PSC. They sort of, you know, told us that we got to do this before we could, they sort of helped us along the way in terms of our strategy. We had a demonstration in front of the school, and at that demonstration, there was tons of press there. Barbara Bowen was there, gave a good speech. She got interviewed by some papers and stuff like that, and news outlets. So we had, you know, I forget his name, the guy from the PSC who does all the, he gave 1 million press releases that he wrote for me and that I signed, or that he quoted me, and I was like, yes, this is good. I felt very important. Yes, Fran, that's right. How could I forget? And we got a lot of press. We actually held a webinar with like over 500 parents, maybe close to 700, where they came and heard what we had to say. And, you know, and before the parent thing, we gathered, I can't even tell you how many hours we spent preparing for that parent thing. It was nerve-wracking. Slides after slides, and we talking, and, you know, we made it a webinar so they couldn't, and we had to borrow someone. We had like up to 1,000 people could come onto the webinar. We had to borrow somebody else, you know, we had to use a resource to get that capability. But we did end up, communicating to the parents so they can hear our sort of side of things. And then we eventually took a strike authorization vote. But I think that, and one of the things that sort of always struck to me was when we were in one of our big faculty meetings, one of our people sort of said, people are dying, of COVID. And this is not about money, this is about saving people's lives. So, when you're thinking, oh, I feel okay to go in, well, think about the entire community and how everybody sort of feels. And right now, it's just the building, we need the building to be checked out. We need to know that it's safe before we can go back. And that was one of our main asks, was that we get a walkthrough of the building, which they were still denying us and not letting us do. And so we did the strike authorization vote. We got over 85% yes for strike. And then the day the final sort of, one other thing that worked in our favor is they're a little bit incompetent. So their reopening plan was to install HEPA filters, and they installed some other type of filter. So they spent like $70,000 on something that wasn't even a HEPA filter. And so we filed a lawsuit. The PSC was able to file a lawsuit because it was like concrete. They didn't follow their own reopening plan. So the lawsuit also put pressure on them because they do not like to spend money on a lawsuit. And then we finally ended up, the day before school was supposed to go back, we ended up going to the building, having to wait probably 2 hours with our experts. And I had to argue with the wonderful Hector Bautista, who was there, but we did get to walk through. It wasn't, and we sort of felt like we had seen what we needed to see in order to feel like comfortable going back. And they also gave us reports and stuff like that. But so in the end, we did feel that we made some good changes and had a lot of success, through our struggle.
Thanks so much, Tina. Wow, that was an incredible amount of work, it sounds like. Thanks for coming twice today to share it. All right,
every time I get on one of these calls, my husband's like, another one?
We appreciate you, thanks. Okay, last but not least, we have Mark Hagan to tell us about the vision beyond the Taylor Law. Mark, we can't hear you.
You're muted, Mark.
Before I do that, I just want to reemphasize what Tina is talking about. I mean, they did what we would call grunt work, right? All this spade work of talking to people and moving them along from just being unhappy to being ready to understanding what the stakes were. And then at the very end, this is actually, Tina didn't tell this one part of the story. They after the walkthrough, that was Yom Kippur, and they had to wait on the union meeting of all the members until after Yom Kippur night was over, right? And the meeting started at like 9 o'clock that night. And all the members decided, right, during this 2-hour meeting from like 9 to 11, that this was good enough, that they had won.
It's funny because Randy Weingarten got involved a little bit, and we had to call her during service. Now that you say that, I remember that her spokesperson was talking to her during service. I should actually say one other thing. We did bring in the lawyer to talk to our people about all of the, we scared people a little bit. We let them know that the Taylor Law is serious and that, we're not taking this lightly, and let them know like all the consequences that could potentially happen, so people were aware.
But they scared CUNY too, and that's the thing. Like Tina mentioned, my brother, and we'd walk around during the summer, and he'd say, "CUNY just treats us like a pesky fly," but by the end, they were not a pesky fly anymore, and CUNY had to treat them seriously and take their concerns for real. So beyond the Taylor Law, just like there was no magic wand for HCCS chapter to move towards strike readiness. There's no magic wand that rids ourselves of the shackles of the Taylor law. Right? We have to be honest, out and out repeal will be a big political lift. But what I do want to do is suggest a variety of ways of thinking and acting that help move us, the PSC, union members in New York State, the people of New York State, state legislatures toward that point of repeal. So I want to actually go back to transit workers, right? As Arthur said, they've struck 3 times despite anti-strike legislation. But let's go further back in time. As he said, until 1940, transit workers worked primarily in 2 private companies, IRT and BMT. And then one day, overnight, they became a public system. So on one day, these workers had the right to strike because they were private sector workers, and the next day they didn't. Why? Well, because of the law, that's the facile answer, but we should instead note that actually nothing else had changed. The work, their pay, their ability to disrupt or not, and yet all of a sudden it was illegal for them to strike. So we should use examples like this to note the absurdity of the law. Here's another example. This one affects us. CUNY is unilaterally withholding our contractually mandated raises, while we, on the other hand, are still prohibited from striking in response. Why is it that only one side can take unilateral action? This is part of the unfortunate tradition. It's an unfortunate tradition of the labor movement for the last 50 or 70 years of comply and grieve, comply and then file a grievance and wait weeks or months for an arbitrator to decide whether CUNY has violated the contract. Well, there's no question here, right? They're just not giving us our money. So this tradition of comply and grieve, unions and their members have come to think of as natural. That's a common sense that needs to be vigorously challenged. So here's another challenge. There is no comparable legislation to the Taylor law in states such as California, Illinois, and Pennsylvania, and 9 other states where unions have the right to strike. Yet the sky has not fallen in those states. And it's one reason why teachers' unions in Chicago and Los Angeles have been able to wage effective strikes. But also in states without, with even worse legislation than the Taylor law. So in 2018, there were effective strikes in West Virginia, effective teacher strikes in West Virginia and Arizona. And they not only bar strikes, but they even disallow mandatory collective bargaining. So under certain conditions, it's possible to win despite restrictive legislation. Now, one common feature of all those strikes was their emphasis on what has come to be called bargaining for the common good, where workers and their unions have been able to build community alliances. So here's another thing to think about, how to frame the right to withhold labor as in the public's benefit. By the way, many of those public-facing demands, in our case, for example, free tuition, are simply prescribed, not allowed. We are not allowed to bargain about free tuition under the Taylor law. This is what's called the scope of bargaining. This is what Arthur was talking about, prohibited subjects. It's much more restricted than in the private sector, and that's no accident. It was meant to split workers from their customers, from their communities. But that doesn't mean we shouldn't make these demands. It's part of breaking the hold of the Taylor laws to make these demands. You know, if enough people have a good faith belief that a law is unjust, it may be too unpopular to punish unions for it. This, I think, is one way to tell the story of HCCS. Whether a court would really impose fines and penalties around fear of death, you know, might well be up to how well our union framed the narrative of the strike. One way to think about strikes and work stoppages under Taylor law conditions is as mass civil disobedience against injustices. You know, that strike in Memphis where King was assassinated, coming down to support it, that was an illegal strike. Now, some legal scholars have also claimed that the Taylor law violates the 13th Amendment of the US Constitution, prohibiting involuntary servitude. A leading scholar in this field is James Pope. He wrote an article about this in the Clarion, our union newspaper, some years ago. While 13th Amendment arguments are unlikely to pass muster in the courts, Pope has suggested that they provide, again, a useful device for raising opposition to the Taylor law prohibitions, getting beyond Taylor law. A concrete effort along these lines came in 2008 and 9, when our union's new executive director, Dean Hubbard, and he was with us for this afternoon session, and we hope to have a session just with him coming up. But he was then at TW Local 100, and he spearheaded a complaint to the International Labor Organization, which found that New York's law banning and penalizing public worker strikes violates fundamental workers' rights protected by international law. At the hostess meeting about a month ago, someone said, well, what are we doing about the supermajorities in the Senate and in the Assembly? And we should be lobbying against Taylor at this point. Cynthia Nixon, let's remember, just 3 years ago, Cynthia Nixon advocated for this repeal in her run for governor. Unfortunately, most unions were too fearful of Cuomo to support her, and some even mocked her, right? Reinforcing the notion that the Taylor law is set in stone and it's up to us to start chipping away at that stone. And one thing is to think about how we might amend the law in various ways. So some suggestions I've heard are to allow work actions around imminent health and safety issues. Another is to lift the ban on advocacy for strikes. A third is, Arthur briefly talked about this idea of protected concerted action is only if you are acting in the name of the union, but that should be changed so that any workers that take concerted action gain legal protection. In 2011, a scholar, Kate Swearingen, wrote in the Columbia Journal of Law and Social Programs, problems suggested revising the Taylor law to, quote, equalize the parties' position at the bargaining table by incorporating into the Taylor law penalties for employers who failed to bargain in good faith. You may remember in a recent contract round, CUNY did not bargain for years and years. That followed a proposal that proposed 2006 legislation to modify the Taylor law so that a court's finding of bad faith bargaining by an employer would result in substantial relief from Taylor law penalties. In other words, if you force us out on strike, then we shouldn't be penalized. Nor would the remaining fines go into the pockets of the agency which had provoked the strike, which is now the practice. And additionally, she argued for limiting prohibitions only to workers performing essential services. That's not us. That suggestion was also made actually by Governor Hugh Carey in 1977, so not just by some academic out of the blue. He offered to remove all penalties on unions except for police, fire, and waste treatment workers, and on the workers themselves if they were provoked into striking by employer action, like them not giving us our contractual raise, in exchange for removal of what is called the Triborough Amendment, which mandates that contracts remain in effect after their expiration until a new contract is established. Essentially, public workers would have become more like private sector workers. By the way, this would also have addressed actions by employers during the life of a contract, such as our withheld raise, a violation of Triborough, yet with no cost to our employer. At the time in 1977, unions chose to decline this offer. They preferred a defensive posture in which contracts could not be changed unilaterally without their consent to an offensive one in which they could fight for better contracts, better working conditions, et cetera. That's a mistake. And we should revisit that. Not just because the trade-off hasn't worked to our benefit, but because it has encouraged a mindset of learned helplessness. From 1967 to 1981, this is under the Taylor law. Taylor law starts in 1967. For the first 14 years afterwards, there were 297 strikes in New York State. What is that? Something like 20 a year. From 1982 to 1997, there were 33. 2 a year. And I can tell you since then, it's much less even. There was no substantive change in the law during all this time. What happened was that unions and members have become accustomed to the Taylor Law's provisions and trimmed their sails. It's our collective common sense that we can't do anything, but common sense can be changed. And that was the power to me of what HCCS did. They didn't say, oh, they didn't throw up their hands and say, well, there's nothing we can do. They were ready to go out on strike. That's what gave them power. And that's what we're trying to do here and what our efforts at strike readiness are all about. And let me just close with one thing. My first union meeting at the Graduate Center, I heard the great Stanley Aronowitz stand up and say, a union which is not ready to strike is not a union. And we can be the union that is ready to strike, whether then you have to assess the circumstances. But let's be ready. Thank you.
Wow. Thanks, Mark. Look at the comments. We're opening up for Q&A. We ask that if you have a question, you put yourself on stack by writing stack or your name in the chat. And when we'll do one at a time. We'll take, please limit your question to a minute maximum. And not every panelist has to answer every question, and we'll give the panelists about 2 minutes to answer those questions they want to answer. And I think we have a few people lined up already. I am going to call on Harry first.
Thanks, Sophia. I have 2 questions, but I'll keep them very brief. One is about another legal question that's not about the Taylor Law necessarily, but I think it has some bearing on the Taylor Law, and that is the 2018 decision of the United States Supreme Court in Janus v. AFSCME, basically determining that it's a First Amendment protection, it's a First Amendment right for public sector workers to opt out of joining the union or indeed paying into the union in any way. So I think that maybe Janus has actually complex effects on union organizing that in many ways in the immediate sense are bad in depressing membership, but might long-term have a different kind of impact in terms of stimulating more energetic unions. So one question is about the political impact of the Janus decision on organizing and on unions. And then the other question, I asked it in the midday session, but I think people in this session will also want to hear the answer, is about this notion of going on strike, breaking the Taylor Law collectively, as that would be, the impact for international student workers who might be concerned about how that affects them further down the line, understanding that they have the protections of the First Amendment like citizens of the United States, but whether this might affect their employment prospects, their immigration prospects, because of the fact that they have defied the law with their friends and comrades. Thanks.
Who wants to take those first question and second question?
I'm going to start with your second question first. It's easier. You know, so for international students, when you get a Taylor Law quote fine, it's not really a fine. I mean, it's a fine because they take money from you, but they take money out of your check. So it means that the next week that you work, if you work 4 days, if you work 5 days, they're going to take a day. They're only going to pay you for 4. So it's not like they go to court and get a fine against you that goes on some kind of a criminal record that it is searchable somewhere. For an adjunct, if an adjunct, I mean, it could be at CUNY, that could be a reason they might give not to rehire you, if, you know, if that was your situation, you know, which would then affect your green card or whatever. But it wouldn't be like getting arrested for a person with a green card. And it's different, you know, in the federal sector, for federal government workers, they're not covered by the National Labor Relations Act either. They have a thing called the Federal Labor Relations Act, FLRA, and that that law not only prohibits striking, it requires that you be fired for striking. You may not hold a job in the government of the United States if you strike. And those who are old enough or who read the history books back in 2000 and, whenever Reagan was president, 1981, he fired 10,000 air traffic controllers. Literally there wasn't anybody left except supervisors. They'd wiped out the entire air traffic controller force. And that was upheld under the First Amendment. There were all kinds of litigation. And maybe that leads into the second question, which is, I think that this right to strike question in face of a law, as opposed to where there isn't a law, the Taylor law has repeatedly been upheld against First Amendment attacks, except to the point that I was talking about, like encouraging, condoning. It's sort of like the courts seem to say it's okay to encourage or condone it as long as it's not imminent. And in the 2005 situation, imminent became when the union executive board actually voted to put out the word to strike. And 5 minutes later, everybody walked off the job. The interesting part about that this question, your question raised to me, is, I told you before that the Taylor law covers union activity. So what I was thinking is that if it only covers union activity and not concerted activity, if everybody resigned from the union, as is their First Amendment right to do, and then went on strike, it might not be illegal, because it wouldn't be covered by the Taylor law. The Taylor law only covers union activity. It's very pointedly only addressed to union activity. So that's a intellectual point to ponder.
Thanks, Arthur. Mark, you wanted to add something?
I think I just have one more intellectual point to ponder, and that's to take up on what Tom Waters put in the chat. When the Supreme Court decision in Janus came down, the logic of the majority was that everything that a union does is political speech. So it used to be that when we went up and lobbied, that was, or gave contributions to politicians, that was political speech. But when you had a grievance about someone's tenure, that was not considered political speech. And so you could separate the two. Now they said that grievance about tenure is also political speech, and we can't compel, Harry, who doesn't want us to grieve for tenure, to contribute his dues or his agency shop fees to helping Sophia get tenure. And he's mean that way, and unfortunately, the minority decision, the minority opinion, just threw up its hands at this and said, we should trust that states know what they're doing when they have agency shop fees, and it helps encourage labor peace. Instead of saying, you know what, if protecting Sophia's tenure is political speech, so is striking, and therefore it's a First Amendment right. And at least put that on the table. But I think this is, again, something that we should be putting on the table, that it is our First Amendment right to strike, even if it's not a winning court argument, but it's part of the public discourse on the Taylor law, I think.
The only thing that I might add about the Janus thing is that I feel like it's a little bit helps with organizing, because you really have to talk to people when they first become a new faculty member about joining the union. It can't just be like, you're going to get dues taken out anyway, so you might as well join. Now you have to actually talk to people and tell them, this is what we do, this is why you should join, da 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 da. And then also, you get these lists. Our school has a pretty high, rate of people who are in the union, but we do get these lists of people who aren't. And then we also have to be, the union presses us to talk to those people too. And so, you get that helps with base building or knowing who's not in your corner, kind of thing.
Great point. Yep. We have Tom next on stack. Tom, do you want to ask your question?
Thanks, Sophia. Yeah, my question also relates to what Harry brought up about the Janus versus Ask Me ruling, but it's a little more like technical, like legal process question. So maybe this is a question for Arthur. Let's say the PSC did go on strike, and then the PERB, the Public Employee Relations Board, did in fact hand down these kind of grievous Taylor law penalties, like suspending automatic dues checkoff and fining us 2 days for like days on strike. If then the PSC council went to federal court and said, you know, we're suing you because these penalties are unconstitutional because we maintain that the Taylor law strike ban is unconstitutional, at least in part based on the Janus versus Ask Me ruling. What is the likelihood that a judge would issue some kind of stay or injunction against those penalties for the length of time that it would then take for that case to be decided? I mean, which could in theory be weeks or months or years, depending on how quickly if it was appealed or it worked its way through the system.
I wouldn't be very optimistic about it. You know, the First Amendment isn't absolute, and the First Amendment is not absolute, right? Like you can't yell fire in a crowded theater, right? That's the classic, I think, Cardozo description of how what some of the limits are on the First Amendment. And I mean, it is interesting what Mark says. In some states, public employees can strike. In Philadelphia, because of the way they're set up, the subway system is governed by the Railway Labor Act, and so the subway workers in Philadelphia have struck, I don't know, Mark, 7 times in the last 30 years, constantly going on strike. So it may be to say, in fact, the governmental interest is not as clear as, you know, as one might argue. I mean, it will be an interesting case to argue. It has been argued, but I think the issue has been argued and people have lost, but maybe in light of Janus, it's time, you know, for a coalition of unions to go in and try that again. In 2002, when the city tried to go in and enjoin the Local 100 from striking, when the state didn't get involved, because it was just a strike vote, we worked with, I think PSC was also, I was counsel to PSC and I was general counsel to PSC and TW at the same time. I think we were all in there, and the UFT and Randy Weingarten, we were all in court together, you know, saying that this injunction that the city was trying to bring under public nuisance law violated people's First Amendment rights. So, you know, and we succeeded. The judge didn't sign their injunction.
You know, the one thing I'd add is, you know, if we can find, if subsequently, you know, we found a trick, we found a magic wand, we found a magic bullet that would work, that would be great, right? But we shouldn't count on that. But we had, at the afternoon session, we had some discussion with James Davis was here, and we were talking about the question of alternate dues arrangements. And, you know, at TW Local 100, it was only after the strike was done that they tried to set those up. And that was problematic because there were various views among the members themselves about whether the strike was good or bad. And some people said, oh, the strike was a failure and therefore I'm not going to pay, and so on. But you know what? Here's going back to Janus, right? And going back to what Tina said, everyone now who becomes a member chooses to become a member. And if we went to them and we said, you've chosen to become a member, give us an alternate way to collect your dues. That should not be, you know, it's a lot of people to contact, but it should not really be a difficult lift to just say, well, if you don't take it out from my paycheck, you can take it out from my checking account or from my credit card. Yes, and you know what, if we did that, then we are again sending a message to CUNY, we're ready.
Great point. David, are you with us?
Yes.
Okay.
Hi, thanks. I'm glad to be at an event with CUNY people, I kind of got into political activity by shutting down City College twice in 1989 and 1991 as a student. So I know CUNY well. I have a question mostly for Arthur Schwartz, about the kind of activity that's protected under the Taylor law. Is only activity by the official hierarchy of the union protected, or is opposition activity protected? For example, if I'm campaigning for a no vote on a contract, is that protected as participation in my union? If a group of us are standing with signs outside of Bronx Housing Court saying DC 37 members support the right to counsel, is that stuff, what are the bounds of what's protected as participation in my union?
You know, well, first of all, DC 37 isn't covered by the Taylor law, so that they're covered under the New York City, whatever it's called.
I'm a state worker, so I'm a court worker, so I'm a state worker.
But I'm not sure it would be covered by the Taylor law, but I can tell you that I actually won a case called Clue versus New York City Transit Authority back in 1995, where the U.S. Court of Appeals for the Second Circuit said that dissident union activity, oppositional activity in a union, was protected by the First Amendment from retaliation. Which, so at least I can tell you that for sure. If you were picketing against your union at the courthouse, or against your union's position, that it would be, and then the employer retaliating against you, it would be protected. Whether or not that's Taylor law protected activity is interesting, because I don't know that the question has ever come up. If the union itself retaliated against you, it might be a violation of those provisions, and there's a union unfair labor practice section in the Taylor law that might violate, but it's definitely protected under the First Amendment.
All right, great to know. Mark or Tina, you have nothing to add? Should I move to the next person? Great. We have Ruth with a question for Tina.
Oh, I was thinking you were going to ask the question, but I'll ask.
Oh, I can, sorry.
I think I remember. I was wondering, I think you mentioned something about it, but I just like your thinking as you were building toward a strike about other job actions. And I think everybody's speculating about that all around, you know, as we all are being faced with this, like, come in business, you know.
I think that everybody was also sort of like, can we just do it remote? Even if they tell us to come in, can we just teach remotely anyway? And just the students will be satisfied, we'll be satisfied. And we were sort of told that any sort of job action, whether it be, you know, everybody calling in sick or something like that, any sort of job action that we decided to do would be could be a violation of the Taylor law. And so even when we were going to potentially strike, the conversation was going to still be about what would that look like, you know, what is that going to look like? So yeah, we had a lawyer, Pete Ryback, who came to speak and answer people's questions. And, you know, he has to tell us sort of the worst case scenario, and that he did. So we have, you know, and so people can be ready. Obviously, I'm hearing that, you know, they potentially could not invoke the Taylor law, but he had to let us know that that's a possibility. And also, in order for the union to support the strike, they needed to have a strike law. They needed all that organizing. They needed to know that we were supported. They needed to know it wasn't 10 people who wanted to do it. So the strike authorization vote had to happen.
Can I say, I think that there are, I've seen over the years a lot of activities that have fallen short of a strike per se that could be defined as a strike. For example, slowdowns, or for example, not a repeated health and safety refusal to do something, but for a shift where I was a situation that I was involved in where 100 bus drivers refused to drive a particular bus because the mirror on the right side had a blind spot, and they said they didn't want to drive it. And although the transit authority yelled Taylor law, in fact, I mean, all that happened is that we had an arbitration, and some people didn't get paid for the day. Some actually did if they had complained about the mirror before. So there are, people like walked out, say office workers walked out for an hour and came back to work. It's going to be very hard for them to invoke the Taylor law against them, unless it was happening every day, and they wanted to run to court and say there's a chance that it's going to happen again. Very often these sporadic, irregular, guerrilla tactics can get around the formality of the procedure that is required under the law.
One thing that happens with those is that there's an assessment after the fact of whether the union encouraged it, condoned it, or came in and said, okay, we'll fix this problem now, so you can, after the hour, you can go back in. But it's a little magic show, what that means.
Right. We have another question that kind of relates to this previous one in the chat. Would it make sense for just a small segment of CUNY to strike? So, with Tina's example, hypothetically, the most hurting segment of CUNY could strike and the rest of us would support the strikers. Or would we all be severely penalized?
I mean, we were concerned at the time because we knew that we were this small little chapter, and we weren't sure if we could do a strike authorization vote, just our chapter, and have it like sort of fly. So I think that's why all the other things were so important, like the press and the pressure that we put on them. So the PSC, like Barbara Bowen and Andrea Hernan was on this call, they said that they were ready to support us in striking, but I really don't know how that would have affected the larger people, like everybody. I don't know how it would have affected everybody if we actually did go on strike.
The on the one hand, if Tina and her crew had gone out, they were the only workers that would have been fined because they were the only workers that would have been striking. But the union penalties, the penalties against the union could have been against the whole union. So, to kind of address the broader point of, was it Amitai that asked this question?
Yeah,
right?
That was me.
Circumstances matter, right? Like there were circumstances that were in this unit's favor, that they were dealing with health and safety, that CUNY had blundered around, but also been so recalcitrant, had refused to talk with them for periods of time, refused to hand over documents and such, right? Circumstances have also mattered in the various transit strikes and in the various years that transit strikes haven't happened, right? So in 2002, for example, I was in the union at that point. The membership was probably more ready to strike in 2002 than in 2005, but it was a year after 9/11, and there was an assessment, right or wrong, right, that it was a tough political lift to go out the year after 9/11. Ironically, what that meant was that in 2005, management, transit, thought that the union had blinked in 2002 and would do it again. So circumstances there. I just told you my whole dissertation thesis. Now I don't have to write it.
Great. We have a factual question that should be quick. What is the law that covers DC 37 that's different from the PSC?
It's called the New York City Collective Bargaining Law. That applies to all city employees. The reason it doesn't apply to transit is because first of all, this law wasn't created till after the Taylor Law, and right around the same time as the Transit Authority used to be a New York City authority. It was a mayoral agency. People don't remember that either. And in the 1970s, the state took it over from New York City as part of to deal with New York City's budget crisis, and they put them under the Taylor Law. And the teachers, New York City teachers, are under the Board of Ed employees are also under the Taylor Law, and CUNY employees are under the Taylor Law. So it's really like straight out city employees, which includes police, fire, sanitation, and DC 37, most DC 37 titles, except the ones that work at CUNY. So and they have a whole separate, their law is similar. It doesn't have I don't think it has a no strike provision like the Taylor Law does. I think the Taylor Law provisions about striking apply to New York City employees, just that particular section. The rest of it doesn't. Then they have their own organizing unfair labor practice bureau that's called the Office of Collective Bargaining.
Great, thanks for answering that. We have two questions in the chat that may or may not be rhetorical questions. Boyd, would you like to ask this, or was this more of a comment? No, you're shaking your head. Tony, yours is also seemingly like that.
Okay, you're talking about a circumstance. I mean, certainly not honoring the contract is an egregious violation of all contracts that I'm aware of. And if we went out on that ground that we weren't paid when we should have been paid, would that preclude our being subjected to Taylor Law penalties? That's a question.
Yes. That's my answer.
So we can do it.
No, I'm saying yes, we would be subject to the penalty.
Yes, we'd be.
This was the offer, though, or part of the offer that Governor Carey made in 1977, that if there was provocation, that there would be no penalties. So again, when we think about amending the Taylor Law, maybe this is a piece.
And Jerry?
So I've been lucky enough to be here for both sessions and hearing both the similarities and the differences between the two. And maybe you can correct me if I'm getting the wrong takeaway here, but the takeaway is not that, the Taylor Law is something iron like gravity or something like that, but something that, we can potentially use to our benefit or to our detriment, and potentially challenge to our benefit or our detriment. And I think we need to be, as Tina said, we want that real honesty with people about the potential of what there is to lose if we lose. But there's also so much to win that we have very little chance of winning if we're not able to challenge the Taylor Law, which is, of course, exactly why it will never be overturned, right? Is because there's so much that we can win if we had the power to strike more easily. So I wonder if, as we think about this, and as we have only 10 minutes left, for those of you on the panel, if you could sort of help us think through like how we determine where that balance is and how we can pick those moments when it is potentially correct to challenge that thing. And maybe it's part of what Mark alluded to earlier, is connecting it like other states have to bargaining for the common good things, and really fighting for something as a larger group. But I would love to sort of take some of these concrete things away here, so that for those of us who think that we do need to push this fight, we can start moving in the right direction.
You know, I'm gonna be a total cynic. You know, after 42 years of doing this, the labor movement, the public sector labor movement, the private sector labor movement, other than a couple of unions, is so, the leadership is so unconcerned with that issue, so unconcerned that, like as Mark said, when Cynthia Nixon ran for governor 3 years ago, and said she supported the you know, the end of the Taylor law, she didn't get a single union that said, yeah, great idea. They all flocked to Andrew Cuomo, who talked about how it was necessary. So I think that the only union I know of that has these kind of discussions about the Taylor law is you guys. Maybe they would have it if the U of T, well, if the U of T leadership, you know, encouraged it, but you know, and the only union that's actually major union that's gone on strike is TW since they created the Taylor law. I mean, there've been a few other strikes that were declared illegal in smaller settings. So, you know, the labor movement, in some ways, I mean, you see situations in a lot of public sector unions these days, including your own union. I remember the first contract I negotiated with PSC was 3 years late, and it got ratified, and a week later we started negotiations for the next one because it expired. And that's not unusual. That's usual. That's often how it happens. The TW generally gets their contract on time because there is this implicit notion that union has put its foot down and said, you know, we want a contract by the deadline. But for the most part, union leadership lets that happen, and the public sector union movement is generally pathetic. You can quote me. Put that in your thesis, Mark.
So I'm going to be a little more hopeful than Arthur. You know, it's a powerful thing. It took us a while to move to the idea of that we're going to talk to our members about strike readiness, and we're going to try to become strike ready. But you know, we are doing it, and it's a task. It involves all that grunt work that Tina was talking about. It involves political strategizing about how, you know, what are building the circumstances, right? So Jerry, you talked again about bargaining for the common good, building alliances, right? Showing that we have power that goes beyond just our membership. And that's not only important for showing CUNY or showing the state, but it's important for showing our members as well, right? And I would say for Tina's unit, it was important for them to be able to show their members that the rest of the PSC stood behind them. So there's this dual piece, right? And maybe here's how I'm more optimistic, you know, like our whole lives, me and Arthur, we've been watching the fall of labor along with the fall of the American working class. And, you know, maybe we can hope that this is coming to an end now and we are reaching a turning point in American history. And maybe we can be near the forefront of that turning point.
I would also say that you really have to get people, the conversations you have to have are about people thinking about the collective and not the individual, because these individual penalties come, but like you guys said, it's for the collective, it's for winning something. And it, you know, and so those are tough conversations because a lot of people don't care about themselves, unfortunately.
But they heard you.
Wow. We're at time, and what a note to end on. Thank you so much, Arthur and Tina and Mark, for this amazing panel. So much information, but also sobering and deeply inspiring, both. I'm going to turn it over to Harry because we will not end here. What are the next steps? What should we do? Tell us how to get involved.
Thanks, Sophia. Yeah, honored to do the outro here. In the manner of an Academy Award speech, I think I just want to put some names on the thank yous for the people who organized the event. It says co-organized by the PSC GC chapter and the Adjunct Project. Those are the organizations involved, but a lot of the individuals that you saw, everybody on the panel for sure, and Sophia, the moderator, but many others played a really instrumental role in organizing the event. Definitely Lynn, our chapter chair, also Zoe Hu, Hannah Goldberg, Jerry Martini, Leanne Fan, who's not here right now. A lot of these people, by the way, are first year PhD students. So talk about coming in hot, organizing these great events really early. You know, we want an optimistic note to end this on. That's super optimistic for me to see that we've got this really lively new generation of activists coming through. Other people involved in the organizing drop more names, but I think the little subcommittee that was formed was primarily the people who were involved. So massive thanks there. Yeah, let me just say a thing or two about what we do from here. And I've got a nice little slide that I can share with people. Let's see if I can find it here. 1 second. Which really details some of the things going on here in the GC chapter. For those of you who are members of the GC chapter, which is not all of you, from all over CUNY, as well as, yeah, broader CUNY-wide things. And some of our friends here will drop links in the chat as I go. Yeah, one thing is we talk here about strike readiness committees and strike readiness work. In some way, I think that our chapter executive committee at the Grad Center and all the department stewards who are involved are kind of one big strike readiness committee. And part of it is working to organize events like these, but a lot of it is doing the kind of, as Mark described it, grunt work, and as Tina detailed so eloquently, the phone calls, the one-on-one conversations, and all of that is essential if you're going to get anywhere near a strike or anywhere near a mass labor action. And so I definitely encourage people to get involved with phone banking. Again, particularly those of you in the GC chapter, I'd love to have you on board. You can sign up with the links in the chat, or you can also drop me an email, which I'll also drop in the chat. And also very much encourage you to get involved in broader organizing surrounding the New Deal for CUNY, this big, ambitious piece of legislation that we are currently pushing as a union. Right now, today, you can get on the phone with, send letters to your legislators, calling for, demanding the funding that CUNY needs right now in what will surely be a rather tumultuous budget process over the coming weeks. So there's a lot that you can do there. But yeah, more broadly, there's a lot of work to do. You can see also here, there's the Public Sector Workers Unite event that I think Boyda posted about in the chat earlier. That's coming up this Sunday. So yeah, I look forward to seeing everybody at future events, hopefully events that are involved with this kind of big conversation about the implications of striking and job actions, but also about the nitty-gritty organizing that is involved as well. For those of you who attended this particular session in the evening, the after hours session, big thanks. Those of you who attended both sessions voluntarily might need to find some other hobbies, but big thanks for that as well. It was wonderful to see everybody. Thanks so much. See you all again soon.
Janus legal precedent. And there has been some conversation in the years since Janus that if all public sector union activity is by definition First Amendment activity, that maybe, in a weird way, Janus actually might allow us to more directly challenge the Taylor law as being blatantly unconstitutional in a way that pre a Supreme Court case codifying this First Amendment stuff might not do. So I was wondering if Arthur, you know, as an attorney, if that's something that you've also been looking into, and if you think that Janice sort of codifying that First Amendment stuff would allow us to maybe push a little bit harder in a legal sense against the ban of striking because it's now more clearly a First Amendment issue for us.
I mean, it's an interesting idea. I know that there have been cases challenging the Taylor law prohibition under the First Amendment. And like I said, I was able in 2005 to get a judge to rule that the union was allowed to have a strike vote using First Amendment principles. Whether somehow I just, it's triable. Is it potentially successful to say, well, what if everybody resigned from the union and they went on strike? Could they stop a strike then? Because the prohibition is against employee organizations advocating a strike, encouraging, condoning, instigating, blah, 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 blah. What if everybody, like, you know, put in a card and said, I resigned from the union, and then they did it, and it became a wildcat? They're actually, unlike in the federal sector, the first case I ever did as a lawyer was, there's a federal law that says that federal employees may not strike. It doesn't say federal employee unions may not condone a strike or call a strike. It says the employees may not strike. And those of you who are old enough might remember under Ronald Reagan, air traffic controllers went on strike and he fired all of them, 10,000 of them, just boom. But that's not the prohibition. The interesting thing about the Taylor law is it's so focused on unions. And Janice does, you know, Janice opens up some interesting questions, whether or not it says, whether or not the courts would then say, oh yeah, well, the Supreme Court said it's free speech not to be in a union, but it's still but whether the unions did it and called a strike probably still would subject them to penalties. But it's an interesting question whether a union could pull a mass resignation and then people strike and say, hey, it's not illegal. Interesting idea.
So there's a few questions. Oh,
Claudia, can I add something to that?
absolutely.
So just to read from Sophia put in the chat, just for people that aren't clear about Janice, right? The Janice case we are referencing refers to a 2018 Supreme Court case that ruled that collecting union fees from non-members in the public sector violates the First Amendment right to free speech. That is the First Amendment right of those that did not want to pay an agency shop fee. And I remember thinking at the time when I read not just the decision was obviously intended to cut the knees out from unions, but the minority opinion, right? Rather than, the minority opinion was based on the idea that states in their infinite wisdom had decided that the agency shop was good for labor peace, right? Almost the same argument that's made by the writers of the Taylor law in the first place. I was disappointed that the minority opinion did not take the First Amendment argument and run it full steam ahead and say, oh yeah, well, if this is First Amendment rights, then workers should also have First Amendment rights to strike. And even though it wouldn't have been the law, it would have only been the minority opinion, it would have at least, you know, kind of created a standard that people could rally around. So, I mean, so I just wanted to, but ultimately, right, these are kind of tricks that you can do, that you can deploy, you know, kind of after the fact to help you out. But ultimately, we have to be just ready to be able to do things, accept the fact that there may be penalties, and understand that at times that's necessary.
So there's a quick question, I think, that's directed at Arthur, which is there a legal distinction between a quote strike vote and a strike authorization vote?
No.
Okay. And then there's a question from Mark in the chat. Do you want to unmute and ask it, Jay?
Sure, thanks for the opportunity. So I appreciate Mark's excellent presentation, but you were going over the red state revolt strikes of 18 and argued the key to their success was making these broad class-wide demands that framed this struggle as a struggle of the entire class, and it prevented the authorities from coming down with the hammer on the strike. So, but I wasn't clear if you were also making the argument that we need not just like to talk about these demands, but to make that a bargaining demand, like for a free higher ed, make the rich pay as our demands, and that we would be striking over them. And I would think to add, and my perspective would be, yes, we have to do that. That would be the only way we could win a strike, if we made these broad class-wide demands.
I tend to agree with you. I mean, it's not my job to put together those demands. I'm just a member like you, right? But I think that if we are positioning ourselves to be strike ready, to gain public support for our demands, that we have to demonstrate, as the Chicago and Los Angeles teachers also did, that we are fighting for the public as well.
Harry, did you have a question?
Yeah, thanks, Claudia. It's a question that has been on my mind a lot, but is asked to me a lot of the time, and I'm not sure I have a good answer. It's primarily for Arthur, but I think it's kind of a broader thing as well. And that is about international students primarily. I think primarily international students when we're talking about CUNY, because something like a quarter of the Grad Center chapter of the PSC is international students, international student workers. What are the potential implications for us, for them, of going on strike? I guess the main concern is whether there would be implications further down the road in terms of citizenship in the country or anything else. But yeah, I'd like to hear Arthur's thoughts on the legal question, but also thoughts from other people, either on the panel or in the chat, about, you know, organizing international student workers.
You mean because they're not what? Because they don't have First Amendment rights?
No, I think they do have First Amendment rights, but whether there would be, I mean, it's just fines that are imposed, right? Ultimately on members, whether that's on your record in some way that might affect your ability to apply for a green card further down the road.
I don't think so. It's a fine that literally means at work. They just, the next paycheck, they just, if you work 5 days, they'll pay you for they won't pay you on the day you strike, and then they deduct 2 more days. So the next week you work, say
One more day, Arthur.
One more day. So the next week you work 5 days, they'll pay you for 4. It doesn't, it's not like a fine that goes to a court that shows up anywhere. It wouldn't show up in your credit record or anything like that.
Thank you. I think most of these other questions were asked.
Tony, that question you just put in the chat is a rhetorical question, I take it?
No, I'm asking, why didn't CUNY Central invoke the Taylor law? Since Arthur just said he doesn't think there's a legal distinction between a strike authorization vote and the strike vote itself.
Well, I think that like I said, gearing up for a Taylor law injunction takes a lot of work, and I think CUNY, and I recall writing to CUNY back in the early 2000s when there was some kind of vote saying, you know, you have their First Amendment. If you want to try to prohibit us, you know, you have a First Amendment problem here, and they didn't write me back and say, go jump in a lake, but they do have a First Amendment problem. So the fact that there was a strike authorization vote and nobody could say it was imminent, because I don't think it had a date. It just said they authorized the board, I think was, the board was authorized to call a strike or something like that. I think they would have been able to take it on. If CUNY Central had gone into court, they would have been able to take it on. And basically you have to say a strike authorization vote is just, you know, a step, but it is not the actual instigating of a strike.
So let's go on. I think Lynn is on stack, and then James.
Yeah, I mean, thank you, everyone. This was really great panel and questions and discussion. So mine is, is sort of thinking about the pieces coming together in terms of being able to push back, right? And there's different things. I mean, one is Tina spoke a lot about the, you know, both about working as well with parents and, you know, the media and the messaging, but also like, I mean, parents and students, right? But also like, you know, the level of internal organization, right, of members, right? And the how critical that is with the various escalating actions. And then, you know, I agree a lot with what Mark has said about the sort of bargaining for common good approach, right? Around, you know, kind of having community support, political support, right? The messaging that resonates with people, all of those various other aspects. There was a like 10-year-old article, Peter Eichler, who now teaches, you know, with SUNY, but graduated from the, got his PhD at the Graduate Center, wrote you know, basically looking at some of the different transit strikes. It was a short article, right? What it did was trying to look at what are the elements that not only made the earlier strikes much more, say, successful than in 2005, but, you know, like, so how were they different? Not just because the strikes were successful or how the strikes were implemented, but the decision of the state whether or not to implement penalties, right? So things like, you know, what kind of, is there real structural power, right? That, you know, maybe that by the time you couldn't really shut things down in the same way, right? When people could work from home, like in 2005, the degree to which labor was behind you, the degree to, you know, the degree which public support, all of these various things. And I guess you know, which made me have a question about how much are these kind of optional penalties based on the power that we show, right? You know, I mean, we know so, you know, and what do we think will make the difference in whether or not the state, you know, decides to come down hard, or is it mainly the state making the decision, or is it, you know, how much CUNY is pressing for it?
So just to remind everybody, thanks for that very detailed question. We're trying, Lynn, and please, both panelists should answer, but just to remind about we're trying to keep questions to a minute and answers to 2 minutes each person. I may not have made that very clear. Mark or Arthur, did you want to answer that or try?
I think that it's hard to answer. You know, it's like I would say the transit strike in 2005 had broad support. It was basically became Roger Toussaint versus Mayor Bloomberg, and Roger came out much better. Even though the mayor had nothing to do with it, it was a state. By that time, the state really was in charge of the transit authority. I think by the third day, the union was running 2-to-1 in support of the strike in popular polls. And, you know, and I remember actually we had live television in the courtroom, and I would walk in on the streets and walk into stores, and everybody said, "Oh yeah, you're the guy representing the union." Nobody said, "Hey, you know, F you." And the judge was, you know, was somewhat sympathetic, but then the union membership voted down the contract that Roger agreed to. And a few months later, the Transit Authority agreed to have a 2-month dues, just a 2-month period of dues reduction. And the mayor sent in Corporation Counsel, who argued it should not be until the union pledged not to strike, and Roger wouldn't do it. And they wound up with 17 months. And I think the union had looked weak. And maybe, you know, I could say maybe if the union, we also had a different judge, because after the strike, the judge that handled the strike got elevated to the Court of Appeals. As his reward, even though he frankly didn't come down that hard on the union. And so it's hard to say, you know, it depends on the judge, it depends on where the union's at, it depends on the strength of the membership, it depends on the support of the labor movement. You know, it's all, there are a lot of factors that come into play. There's not one answer.
Yeah, circumstances matter, right? So in 1966, the union actually faced a stiffer law called Condon-Wadlin, which allowed strikers to be fired, but it turned out it was too stiff. Like, it was unusable against 35,000 people. In 1980, when the union went on strike, they were just coming off of 4 years of fiscal crisis austerity, right? And so it was able to be framed as a strike about the workers calculated that they had lost 30% to inflation over the previous 4 years. Arthur's talked about this oddity in 2005 where the penalty got much worse at the end, just because the union decided to challenge, like, rather than just say, yeah, okay, we'll never go on strike again and cross that bridge when they came to it, they tried to make it a principled issue, and it cost them. Similarly, with the campus schools, it was important that, as Tina said, right, it was important on the one hand that the union tried to cooperate, right, for its own members. It was important in mobilizing its own members that the union leadership could say, look, we're trying everything we can, and they are rebuffing us, we have no choice. And on the other hand, that the Hunter admin in some ways seemed completely incompetent. So all of these, when the moment comes, right, to decide it's time to go out, you have to weigh these factors. I'll just say one more thing. The Transit Workers Union was actually more prepared to strike it at its previous contract in 2002 than in 2005, but 9/11 had happened just a year before. And that made it very difficult, right? Politically, very difficult. So all the circumstances come into play, but first you've got to be ready, and then you can decide, does this make sense?
Thanks, Mark. I think James is next. James Davis.
Yeah, hi. Thanks, Mark and Arthur, and really good discussion. Really grateful to you guys and to Tina. 2 questions real quick. I think maybe they're related. I'll try to be brief. I'm wondering if these kind of distinctions make sense. Is there a difference in terms either of organizing or in terms of the way that, you know, legal authorities look at the Taylor Law between a defensive strike of the kind that Tina's unit was contemplating, very clear safety risk, or versus an offensive strike, either taken within a contract, in the context of contract negotiations, or taken outside of a context of contract negotiations, you know, a strike for resources of whatever kind. That's a set of distinctions that when I'm talking to members doing phone banking, or when I'm talking to colleagues on my campus executive committee, I mean, it's not a hard and fast typology, but they engender different kinds of reactions. And so I'm wondering whether those are useful distinctions or if they're artificial and I should correct my thinking. And then the related question is, where do you see, given the loss of dues checkoff that's mandatory, even though there's not a compulsory like duration attached to it, at what point in organizing does it make sense to to establish and to organize around alternate forms of dues collection? Thank you.
Two very different questions. The first one is, I would say legally, there's no distinction. There isn't. I mean, under case law, there's no distinction. That's what that ATU decision had to do with. Is it good to have alternate forms of dues collection? I would say absolutely, because if you're going to plan an action, because TWU wound up like just starting to build a system of paying by credit card or paying, on the floor at work after they lost the dues checkoff, and it was woefully inadequate. It was, but it also, it's one of the things you also have to consider when you decide to do it. How supportive are people going to be? And I would say that TWU was actually not prepared for a strike when they struck. And Mark, I think Mark was chief of staff or something when this was happening. But oh no, you weren't anymore. But the union was not prepared, and so they weren't prepared. Other than the PR side, they hired great PR people, but they hadn't prepared their members. They hadn't prepared, when they settled the contract, and then when they went to collect dues, a lot of people said, "Sorry, if I don't have to pay you that $50 a month, $60 a month, I'm not going to pay it."
Mark? did you
James, I'd argue, I can't add anything to Arthur on question one, but on question two, I'd argue that it makes sense for the union to set up these procedures in advance. And I'd also point out that someone mentioned in the chat that Janus has turned out to be a double-edged sword in a certain way, that it has made unions have to be much more concerned about signing members up, because it's no longer that, well, we could get the agency shop fee anyway, right? So to the extent that members have signed up, they have made that represented workers have signed up to be members. They have already made a conscious decision to pay dues. And so it should not be that different a lift to say to them, well, all we're asking you to do is give us an alternate way to collect those dues that you've already agreed to. Give us, give us the ability to collect dues not using the employer. We could even make the case that we will be stronger as a union when we don't have to depend on the employer to collect those dues. And the other advantage, of course, is that after the strike, as Arthur said, because in 2005, there were mixed views about whether the strike was successful or not, people that had voted against the contract said, to hell with it. But if you've already signed them up, you've kind of already signed them up.
Thanks, Mark. I think Tony has a question, and that might have to be our last one for time.
Yeah, I just seem to recall there was a big anti-war march that was scheduled, and Toussaint was in prison, and there was talk, much talk, of marching past the prison, over the bridge and past the prison, uniting anti-war with labor, which is the last thing the power structure of this country wants. That's their worst nightmare. Do you recall that? Because this was during the Iraq conflict, of course.
I don't. I'm not saying that that wasn't true. I just don't recall it. But I mean, insofar as you're making a general point, it goes again to the question of bargaining for the common good and of having public support for any action. Arthur, I don't know. Do you have anything to add to that?
Thanks, everyone, for your great questions. Thank you to the presenters. And I think Lynn's going to help kind of wrap this session up. Thanks, Lynn.
All right. Yeah, as I said, thank you all. This is really phenomenal. So I'm here to do the, okay, how can we all get involved? And many of us are actually extremely involved in the work, both in terms of strike readiness, in terms of, you know, our fights around against layoffs, around the issues around class size, around getting funding, right, and a new deal for CUNY, and just the slew of different issues that we're involved in across our campuses. Leanne helpfully made a slide. I don't know, can I share it, or I just want to go through a couple of quick things. I would probably need to be a co-host.
I'll share it because I'm currently the
You have
host
it.
somehow, so I'll
Okay,
share.
right, great. Okay, if you can do it. So I want to plug a couple of different things. And first of all, I think there's a range of people from our chapter. By the way, I'm Lynn Turner. I'm the chapter chair at the Graduate Center. A lot of people from our chapter here, as well as other chapters. We do have a form for those who are our chapter members to get involved. So I don't know if Harry, if you can share that in the chat. Strike readiness is one of the things we have, as well as a slew of other ways to get involved in the work of our chapter. Secondly, we are doing phoning, because so much of this is so important. And as we heard from Tina's presentation, right, the work that's done, there's nothing replaces the work that's done by reaching out and engaging our own members around the issue. So throughout the PSC, throughout the union, all the chapters are involved in strike readiness outreach through phoning, and we are as well at the Graduate Center. There's Tuesday evening phoning, and I believe Thursday evening phoning, where you can choose which one to participate in. The union-wide, once a month, there is like a phoning party, and we're also considering doing our own chapter-wide phoning party. So we really want to, the more people that we have phoning, one, the more fun it is, the more people we reach, the sooner we get to strike readiness. There's a link there. I don't know if Harry, if you can share the link to sign up for our chapter phoning. And if people from other chapters, you can share your own links, but please do join us. Also, many chapters have strike readiness committees on, we do a lot of our work both through the phoning as well as through our political education subcommittee. This is one of the events. We're looking at a follow-up around delving more deeply into strategies like the International Labor Organization strategies and other strategies to fight back against the Taylor Law. So you can join those. And then there's also, this is a key week for New Deal for CUNY organizing, but particularly around getting revenue into the coffers. There's a whole coalition around a slew of tax the rich proposals, legislation that's called Invest in Our New York. Our union is participating in that. The budget is finalized by April 1st. And basically we need to be pressing for like $270 million more, than what Cuomo has in his budget right now. So sign up. There's different things that you can do. One is sending a letter to legislators. If people can just send that right now, all you do is click, and you can also find your legislator and click and send your letters so that they support and that they're also pushing the Assembly and State Senate leadership to really have the best deals possible. And the second thing is we did kind of a tweet storm on Monday, but we can still tweet. So we're going to put some tweets in the chat so people can tweet right, immediately, about New Deal for CUNY and investing in New York. And I'll also put in a link for those that want to get involved in legislative meetings. Thank you, everybody.
Thanks, Lynn. Are we done then? We saying goodbye? Thank you, everybody.